I think it is an assessment to have them go into SATs and move on.
What is the violation?
Alcohol and weed. I have done everything in my power to try to keep you out of custody. You have two open DWIs. I was now going to grant the fact that you had negotiated an intensive outpatient treatment. You now are testing positive for alcohol and marijuana while you're on bond for this case. And I have told you repeatedly that you are at no tolerance, Mr. Jones.
I don't do drugs. Period and point blank.
I have here,
Don't say anything. Can I get a copy of the bond violations before we discuss
Is it
it?
impending?
it's, yeah, it's in ready for judge.
I don't know why it's not cool.
March 13th, the results were confirmed by the lab for alcohol and THC. Oh, wait. Joshua Dante Jones, right? Joshua Dante Jones?
It just. That's
This has got, I don't know, something's wrong here.
I'm not understanding. I'm not saying.
Something's wrong. Oh. We need to put pretrial services on probation, man.
I'm not sure.
I mean, it says here, Mr. Jones,
I don't see it in ready for judge.
no, it's wrong. It's wrong. Let me see it. It's wrong. Let me see. Yeah, it's wrong. It's a Joshua Dante.
Okay.
It's the exact same. You're good.
So we're good.
Hey,
It wasn't you. We're good.
that's not you.
Let's go talk again.
Sorry to scare you.
Let's go talk.
He's good.
Judge, you stated this was in ready for judge?
Don't worry about it. I want to apologize for getting mad at you. I had the wrong person, so it wasn't you. So I'm sorry for raising my voice and getting upset with you. And the reason I got so upset was because you have two open DWIs. It's serious business. It's not a, and so if I see someone that has those kind of cases that are open and then they start having more violations, that really tells me that there's a problem, which is not your case. I mean, I haven't seen any violations, which I'm hoping it stays that way. The idea is that you learn something when you get here, so you leave better than you came, because the last thing we want is for you to become a statistic. We have enough of that. We don't want any more. We don't want any more death on our streets. That's exactly what we're trying to prevent. And everything we do now here is to help you and give you the tools to make you better when you go out in the world, so that you think next time, if you do want to get lit, right? If you want to have 32 shots of tequila, 52 joints or whatever it may be, right? That you think before getting into a car. Because God forbid, it's that one mistake that you dig such a hole you never crawl out of. That's the idea, You've worked a great deal here, really, where they're going to dismiss one of your DWIs, you're pleading to the other one. Nevertheless, when an officer pulls you over, the first thing they do, what do you think they do? They look at your record because they want to know who they're dealing with. If they look at your record and they go up to you in the car and they smell alcohol or dope, it's probably not going to go well. So the idea is, if you're going to get lit, if you're going to have that, be like that, take an Uber. Do you understand? The agreement that you worked out is, like I said, they're going to dismiss one of the DWIs. You're pleading guilty to one of the DWIs, so it will go on your record. You are now entering into an agreement, a plea bargain with the state, The agreement is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. You will do a TRAS with conditions. You have already done the TRAS. The TRAS has recommended intensive outpatient treatment, followed by supportive outpatient treatment, which is good. I'm telling you, I thought they were going to order you to do inpatient treatment. That's what I thought they were going to do. So this is great for you because you're not going into lockup. But understand, it's not easy. You have to get it done. If you don't, you understand. No drugs, no alcohol, no breath test refusal. So if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. Guardian interlock, a $100 one-time donation to Mothers Against Drunk Driving, and 25 hours of community service. I will make you a deal. Your license is now suspended. I had them look it up to see whether you can drive or not. You can't drive now because your license is suspended. It's suspended until 2026 as to what the state saw and looked up. If you get your license back, I will waive that community service for you. I would rather you spend the time to try to get your license back and get liability insurance, car insurance. If you do, I'll take off the 25 hours of community service. You understand? If you fail at this agreement, I will issue a warrant for your arrest. I'm going to bring you back out. We're going to have a talk about whether you violated this probation. If you do, you're looking at 180 days in jail. You understand?
Stop.
The worst possible thing you can do is just take off. If you do, that's an instant warrant. The other worst possible thing, if you pick up another DWI. If you do, I'm just going to lose even more hair. Don't, really. If you ever have a problem, come back, talk to us. We can always work it out. There's never nothing that we can't work out. Anything can be worked out. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, to examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense of driving while intoxicated?
Yes.
I'm going to find you guilty. I'm going to follow the agreement. I'm not going to suspend your license. It's already suspended because of the ALR hearing. So don't just start driving until you get it back. Because you don't have a license, we're going to order you to get a portable device. I've been paying for it now while you're on bond for this case. I can't pay for it any further. Reduce his fees, please. The other thing that you need to understand is DWI is big business. There is a $3,000 surcharge that one normally tack onto this. I'm going to take it off now. But from now on, you ever pick up another DWI, that's a second. From now on, it's a minimum of 30 days in jail and a $6,000 surcharge on a second DWI. Do you understand? All right. Good luck, sir. Thanks, Jimmy. You can wait now. Good morning, Ms. Hall.
Good morning.
Ma'am, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Oh, you're also charged with evading arrest in a motor vehicle. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 19th, 2025, an officer observed a vehicle on Northwest Freeway in Harris County, Texas. The defendant was stopped at a red light when the officer was stopped at a red light when the officer's traffic signal changed to green. The officer began to go through the intersection and observed a vehicle at a high rate of speed disregard a solid red light. A traffic stop was initiated. The defendant refused to stop and continued to accelerate from units to actively evade and lose units. The defendant ran a red light and made a left turn, then traveled the wrong way through a U-turn, then continued down the street at a high rate of speed. The officers continued to pursue the defendant with emergency equipment activated at speeds over 100 miles per hour. The defendant continued to accelerate through multiple red lights, turned her headlights off and drove in circles under the highway and drove the wrong way on the service road while attempting to evade from the officers. The pursuit came to an end when the defendant turned onto a dead-end road. The defendant tried to go around the officer's vehicle and struck the front end of the patrol vehicle. The defendant evaded for approximately 5 to 4 miles. A loaded handgun was found in the glove box of her vehicle.
Ms. Hall, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, see if she has a license, please?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive maniacally again. If I find that you drive like this, I'm going to put you in jail the first thing, and then I will take your ability to drive away from you permanently while this case is open. Do you understand?
Yes, ma'am.
I am ordering you not to be in possession of any weapons.
Her driver's license is eligible.
Okay. Do you have the ability to hire a lawyer, ma'am?
I have a court appointed already. I met with her Monday when I came to court.
That may be in your felony case, but just because you have one in a felony case doesn't mean that you have one here.
Okay,
So-
may I apply for one?
Okay, I'll give Deputy Miranda, I'll give you an application. I'm gonna have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we generate your bond conditions. Do not leave until you sign them,
Yes, sir.
please. Good morning, Ms. Perez. Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Officer, as part of a proactive prostitution investigation, was driving around the 32nd hundred block of Tidwell Road. The officer rolled down his window near the defendant and the defendant approached. The defendant offered and agreed to engage in deviant sexual conduct in the form of performing oral sex for a fee of $100.
Okay, Ms. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to engage in like behavior. Otherwise, I will revoke your bond and put you in jail. You understand, ma'am? Do you need a lawyer? Can we provide you a lawyer?
Oh, yes, please.
Okay, I need you to fill out an application. Deputy Etchigoin is going to give you an application. I need you to fill it out for me. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box while we find you someone. Do not leave until you sign our bond conditions. Okay. You're Mr. Walker. Sir, Detrick Walker.
Yes, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you can afford one will be appointed to you, sir.
All right. On Wednesday, March 19th, 2025, officers were dispatched to a call for service at 10219 Rolston Lane in Harris County, Texas, regarding disturbance. Upon the arrival, the officer spoke to the complainant. The complainant and the defendant had been roommates since January of this year, and the complainant stated that her boyfriend, the defendant's brother, were arguing about his friend being in their house as they were in the bedroom. All of a sudden, the defendant walked into her room and started talking about rent money. The complainant stated that the defendant started getting in her face, but she was backed away because she was afraid that the defendant would hit her. The defendant ended up grabbing the right side of her jeans and pulling her off the bed and dropped her to the ground, causing pain on her back. The complainant stated the defendant threatened her, stating, "I will break your jaw and make you call 911. The defendant stated her boyfriend and her friend separated to prevent a further altercation and that she wanted to press charges.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of weapons. A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file additional charges against you. It's one of the worst cases that you can pick up, a violation of protective order. Do you understand?
Yes, sir.
I will protect my county at all costs. I don't care who you are. I don't care what you are. I will put you in jail and make your bond sky high. You become a problem and you endanger my community. Do you understand?
Yes, sir.
Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, we're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll then have you take a seat in the jury box, we'll get your bond conditions, we'll have you sign it, and then you'll be free to go. Please.